Welcome to the Ending Sexploitation podcast, where we decode sexual harm and provide you with active solutions. I'm your host, Kaylee McNamara.
Hello, my name is Peter Gentala. I have the privilege of serving as Senior Legal Counsel at the National Center on Sexual Exploitation Law Center. It's a joy to be with you and to take a little bit of time and reflect on the ways that sexual abuse and sexual exploitation are being pervaded through social media right now. We're going to take just a few minutes and have an overview of what has been a very eventful year since the last summit when it comes to social media and online sexual abuse. It's also been an encouraging year. I think you'll see that there's a lot to celebrate, but there's also a lot left to do. So let's get started. The focus of our time together is going to be on how accountability and really the rule of law can be brought to bear on the internet when it comes to sexual abuse and sexual exploitation. We're going to talk about three general areas. We're going to talk about the scope and scale of the problem. Exactly how difficult is it out there? What are the challenges? Where are we as a culture when it comes to sexual abuse and sexual exploitation online and in social media? Then we're going to talk about the current legal standards and how it's working in the courts right now. And what are the challenges to true legal accountability in this area? And finally, we're going to overview what has happened in the last year and why the voice of survivors has been so powerful and so important as we move towards a lasting, healthy change in this area. So let's start first with where we are now. What is our track record as a society when it comes to sexual abuse and sexual exploitation and social media? Let's start with the fact that predators love social media. They love it because it offers them all of the features that you see on this slide. It offers them accessible potential victims, millions of them. Many of them are vulnerable because they are young. They are vulnerable because they are in settings that can't be supervised by adults. It's the perfect place to groom, to target, and to exploit victims of victims for sexual abuse. Additionally, it offers them an entire marketplace, a series of marketplaces to sell their wares, which is the products of exploitation. Predators love social media because it often gives them anonymous circumstances. It gives them the ability to not have accountability. It gives them the ability to hide in the shadows, to have access to vulnerable victims like children, and to do it in an environment where no one else sees, in private conversations. By the same token, predators love the fact that the internet gives them an environment where they can't be held accountable. And that accountability comes in the actual moments when they're grooming their victims, but it also comes later on in the fact that it's hard for law enforcement to track them. It's hard for them to be held accountable in the court system, both criminally and civilly. And as we will see, even the internet provider platforms themselves operate in what is essentially an accountability-free zone. Finally, predators love social media because it gives them an economic advantage. It gives them a place to take a single or a small group of exploited victims, which are crimes, but then to be able to sell them across internet platforms that offer extensive marketplaces, hundreds of thousands of potential buyers for the product of that exploitive act. So the money, the incentive for predators is very, very heavy. So with these dynamics, this is why social media is such a powerful draw for sexual predators. What kinds of predation are common on the internet? Well, the social media offers an opportunity for sex traffickers and those who sexually exploit others by selling them for sexual purposes to have a broad marketplace. We saw this with Craigslist. We saw this with Backpage.com. These marketplaces focus on selling illicit sex and selling victims of sexual exploitation. Sexual extortion is something we're going to talk about significantly, but essentially it's blackmail, where the extorted person has a compromising photo, and then the exploiter or the trafficker, because it's really not distinguishable from human trafficking at the end of the day, is able to cause the exploited person to continue to do things that they don't want to do. And through that threatening process, lives are being destroyed. The internet offers a forum for the creation, receipt, and distribution of child sex abuse material. This is commonly known, and even the legal name for it under federal law is child pornography. But we're going to talk about it today in the terms of what it is. It's a photograph of a crime scene, and every image and every video is child sex abuse material. It's a memorialized photo or video of a child being sexually abused. Then we have the large category of non-consensual pornography. This is often referred to as revenge porn, but it basically focuses on a captured image or video of a sexual act that is not consensually being distributed. Sometimes the original image or video might have been consensually recorded, but it is now in its distribution not consensually being distributed. And this distribution can have a devastating scope, perhaps to hundreds of thousands, if not millions of people. Then we have another clearly non-consensual category, sexual assault. It's a sad fact that a lot of internet websites have images of sexual assault that are recorded and put online. So you have the initial assault, and then hundreds of thousands of times or millions of times it's being viewed by others afterwards. This is a heartbreaking feature of the so-called tube type of internet platform, where users are able to upload images and there's very little screening, and then those images can be sent out across the full breadth of their platform. And the final category that is, and these are all just typical of the type of exploitation that's available through social media, is voyeur pornography. And this would be any type of hidden camera, such as upskirting and other things like that, where the perpetrator is using a unknown hidden camera in order to harm the victim. Let's talk a little bit about how pervasive child sex abuse material is on the internet right now. In 2020, the National Center on Missing and Exploited Children, which is the national clearinghouse in the United States for child sex abuse material, received 21.7 million reports of suspected child sex abuse material, or CSAM. I'm going to use those terms interchangeably for the purpose of this conversation. That's a 28% increase over the total number of reports in the prior year. Between 2018 and 2020, Project Arachnid, which is an initiative of the Canadian Centre for the Protection of Children, detected 5.4 different instances of CSAM media. That Project Arachnid is a very powerful tool, and it gives a lot of granularity into the data. So here's a little bit more about what Project Arachnid found. They found that there was high recidivism, or repeat images. Nearly half of the CSAM that was intercepted and issued a takedown notice by Project Arachnid and the Canadian Centre for the Protection of Children had already been flagged by the provider. So these same images are being re-uploaded and used again. Also, through Project Arachnid, we know that when it comes to child sex abuse material, it's not just something that's on the dark web. You may have heard this term before, the dark web. What it means is a place on the internet where there's very little accountability, where the users that interact with each other don't have either identifying information available. It's used often to evade any form of legal accountability, certainly law enforcement. There's a view out there that's common that child sex abuse material only exists on the dark web. Sadly, that is not the case. the images themselves are often right on the front porch of the internet. Certainly on a website like Pornhub, which focuses on sexually explicit images to begin with, but also on mainstream social media sites like Facebook and Twitter. So according to the Canadian Centre for the Protection of Children, the vast majority of the images are actually hosted on clear web websites, that is in the main channel of the internet, not just the dark web. What the dark web is used for is communication for the distribution of these images, but then they're stripped of identifying information and posted on the clear web. The New York Times ran an investigative piece in September of 2019 that covered how extensive the situation is on the internet and how deep this problem is. I'm going to read just a couple excerpts that give an overview of what the Times found. The New York Times found an insatiable criminal underworld that has exploited the flawed and insufficient efforts to contain it. As with hate speech and terrorist propaganda, many tech companies failed to adequately police sexual abuse imagery on their platforms, or failed to cooperate sufficiently with the authorities when they found it. The Times reviewed over 10,000 pages of police and court documents, conducted software tests to assess the availability of the imagery through search engines, accompanied detectives on raids, and spoke with investigators, lawmakers, tech executives, and government officials. The reporting included conversations with an admitted pedophile who concealed his identity using encryption software and who runs a site that is hosted as many as 17,000 such images. In interviews, victims across the United States described in heart-wrenching detail how their lives had been upended by the abuse. Children raped by relatives and strangers alike being told it was normal. Adults, now years removed from their abuse, still living in fear of being recognized from photos and videos on the internet. And parents of the abused, struggling to cope with the guilt of not having prevented it and their powerlessness over stopping its online spread. The Times reporting revealed a problem global in scope. Most of the images found last year were traced to other countries. But the role of Silicon Valley itself has played a significant part in facilitating this problem, according to authorities. This is a picture of one of the images of sextortion. This is Daniel Perry. He's a young man who took his own life in Scotland in 2013. And when I think of the victims of this type of sexual abuse, I always think of Daniel first, because his case is the first one I ever became aware of. And I can still remember where I was and when it was when I first heard about the tragedy of Daniel's case. I'm going to share with you something that Daniel's mom said after he took his own life. She said, "He was not the type of person who let things get him down. He was a happy laddie, not depressed, not the type of person you would think would take their own life. Knowing him as I do, he has felt embarrassed, horrified, and has thought he's let everybody down. We're a very close family, and I just wish that he had come to me and said something." These sentiments from Mrs. Perry are very common among parents whose children have been targeted on social media. And in Daniel's case, the authorities in Scotland traced the blackmailers back to Latin America, and there's still an effort underway right now to extradite the traffickers who targeted him. But Daniel didn't know what to do. He didn't know who to reach out to. He felt like there was no way that he could ever turn the table on his blackmailers, and eventually he took his own life. Tevin Tobler took his life at the age of 16. He lives in Utah, and I want to share with you what his parents had to say after it was discovered that through a sextortion scandal, or not a scandal, but through sextortion, he felt he had nothing that he could do and no options but to take his own life. Tevin's mom said, "I want to tell all parents that because that it doesn't matter how close you think you are never as close as you think you are. Because I would have bet money that Tevin would have told me, but he didn't. You're a 16-year-old boy. You're not going to prison for showing your abs or for anything else. At this point, it's not a true felony," she continued. "We're really a religious family. It's easy to feel shame and to feel those things. And these people make you feel that because they know they can tear you down, it's important that our kids don't. We can help them not feel that way." So what is the status of the law? What is the rule of law doing to prevent the kind of sextortion and other types of exploitive behaviors online that took the lives of Tevin and Daniel, among many other victims? Well, one of the main challenges is something you've probably heard about and probably something you know significant about, Section 230 of the Communications Decency Act. Now, Section 230 is an extensive topic, and we're not going to get into it deeply during this presentation. There is another presentation that's part of the summit that will dive a little bit into Section 230 with some legal experts, and you'll find that that's a panel discussion that you can look at in the summit. In the materials that accompany this presentation, I'll have a few other resources with regard to Section 230. The first thing to note about Section 230 is that it's part of a broader piece of legislation, the Communications Decency Act. And the Communications Decency Act itself is part of a broader piece of legislation, the Telecommunications Act of 1996. 1996. The world was a very different place in 1996, and the internet was an entirely different piece of technological infrastructure in 1996. So what Congress understood about the internet and Congress's ability to understand what the internet would become was obviously a real challenge for lawmakers. This provision that's on the screen right now is one of the central provisions of the Communications Decency Act, and it's what is constantly raised by social media platforms when they ask courts to hold them immune. It reads, "No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider." Well, what does that mean? What the internet companies have been arguing, and with significant success in court over the last several years, almost 2 decades now, is that it means anytime they are provided content and content of any type by a third party, they can never be held responsible for that content being distributed on their platform and using their technology. This is the logic of Section 230 as the social media companies and as the overtly sexual online providers like Pornhub would have it. They argue that as long as you have a situation where one person is exploiting another person, in this case, let's say A exploits B, or simply comes into possession of images or video of B's exploitation, and then A posts that exploitive image on a social media platform, and then the social media platform does what it does best, distributes it millions of times, if not hundreds of millions of times, and profits monetarily from the distribution of that image. Then the social media platform argues that it can never be held responsible at all for the distribution and monetization of that exploitive image. They say that recourse only is with the primary producer of that content, the person who uploaded it to their platform. They would say, never mind the platform, never mind the fact that we are a well-funded multinational corporation with billions of dollars of capitalization. Never mind what we can do on our side, just focus on the person who uploaded the sexually explicit, and exploitive image. Here's an example of the attorneys for Facebook making this argument in court. Whatever more or different Facebook allegedly should have done about third-party communications, in this case, we're talking about communications between a sex trafficker and their victim, and the victims were eventually physically, sexually exploited by the traffickers. So whatever more or different Facebook allegedly should have done about those third-party communications, like prevent them, block them, remove them, edit them, flag them, or warn about them, it doesn't change the fact that plaintiffs' claims derive from Facebook's role as a publisher, which is why they are prohibited by Section 230(c)(1, no matter how artfully pled. You can see this is kind of a legal argument, but you can see how Facebook is saying, look at the third party, never look to us. We don't even have a duty to warn when we know that the content is dangerous. Here's a similar example, this time from attorneys for Pornhub. The described content is heinous, disturbing, and almost certainly criminal. This putative class action, however, attempts to shift legal liability from plaintiffs' assailants to Pornhub for allegedly owning, operating, and controlling websites that provided a public video platform the perpetrators used to share their video content. So they would focus only on the primary abuse, again, A exploiting B, and say that there is no legal accountability and no legal liability for what their platform does. What does Pornhub's platform do? It takes that image and it sends it throughout the world for hundreds of millions of viewers so that the victims can be re-traumatized over and over again. Supreme Court Associate Justice Clarence Thomas has recognized the challenges that Section 230 has created, and particularly the way it's being interpreted right now. Here's what Justice Thomas wrote in October of 2020. This was not in an actual case heard by the court, but it was in a separate statement when the court decided not to hear a case about Section 230. The Supreme Court of the United States has not yet given a definitive interpretation to Section 230. So all of the cases that exist currently right now are at the appellate court level or in federal district court. We don't have that final definitive word about how the legislation should be interpreted from the Supreme Court. Here's Justice Thomas. Paring back the sweeping immunity courts have read into Section 230 would not necessarily render defendants liable for online misconduct. It simply would give plaintiffs a chance to raise their claims in the first place. Plaintiffs still must prove the merits of their cases, and some claims will undoubtedly fail. Moreover, states and federal government are free to update their liability laws to make them more appropriate for an internet-driven society. Extending 230 immunity beyond the natural reading of the text can have serious consequences. Before giving companies immunity from civil claims for knowingly hosting illegal child pornography or for race discrimination, we should be certain that that is what the law demands. So you can see that the interpretation of Section 230 is something that is still very much being litigated. It's in the courts now, and there are many calls for reform, including in the highest court of the land. What are the legal claims that survivors of sexual exploitation and abuse can summon to their side when they come to court? Well, here are some examples. But first, I want to mention something that Clarence Thomas said. Justice Thomas pointed out that it's not just the ability to raise these claims in court, it's the access to court itself. The way Section 230 is being interpreted right now, it shuts off the lawsuit essentially before it even begins. An internet service provider or social media company can file a motion to dismiss at the very beginning of the lawsuit. If a judge agrees and dismisses the suit on Section 230, the ability to discover evidence, the ability to bring their claims into court, the ability to have a fair hearing of the claims themselves legally is completely denied to survivors of sexual exploitation. There are many laws that protect the rights of survivors. Here are some examples. Federal trafficking claims under the Trafficking Victims Protection Act. Federal law gives extensive protection for the survivors of sex trafficking. And it also focuses on not just the initial traffickers, but anyone who knowingly profits from sex trafficking. These are powerful legal claims, and they represent a powerful opportunity to protect survivors, but the lawsuit has to be allowed to move forward for that to happen. Congress recognized the significance of the Trafficking Victims Protection Act by making one of the only changes to Section 230 since 1996. In 2018, Congress made changes with the FOSTA-SESTA Act. This act exempted federal trafficking laws from Section 230, but internet service providers, including Facebook, are still claiming in court that they can't be held accountable under FOSTA-SESTA. There are various civil claims, such as negligence, that can be brought. Negligence is essentially saying that someone has unreasonably ignored or fallen short of a duty of care. And that certainly is the case in many of these situations. There are civil conspiracy claims, child sexual exploitation laws in both the federal and state levels. Product liability claims is very significant. There's a very important ruling out of the Ninth Circuit recently that said that the application Snapchat, that a claim against Snapchat for the way its platform functioned could move forward when a feature of Snapchat had induced young people across the country to unreasonably speed. The app would take a little screenshot and show how fast they were traveling at the time that they were taking the screenshot. And many young people took advantage of that to share with their friends instances of traveling faster than 100 miles per hour. Well, unsurprisingly, many young people were hurt. Many were killed in high-speed vehicle crashes. And the Ninth Circuit has green-lighted a product liability lawsuit to move forward, despite Section 230, against Snapchat. That's a very recent case. And it gives hope that a very important area of the law, product liability, can still have some traction. There are potential contract claims. All of these forms of sexual abuse are non-consensual in one form or another. And there are times when contract claims or breach of contract claims can be brought on behalf of the survivors. And then there are various other torts, such as invasion of privacy or infliction of emotional distress, false light. Many states now have a specific tort for non-consensual pornography, for putting private images of another person out on the internet without their consent. So these are an example of just some of the tools that are in the legal toolbox to help survivors. But the courthouse, again, has to be open first. Now let's shift and look at the final part of our time together, which is where we stand now. And there's a lot of good news to report. In the last year, we have seen an unprecedented movement of survivors stepping up, stepping forward, and courageously sharing their stories. Sometimes they do this in lawsuits. Sometimes they do this in interviews with the media. Sometimes they agree to interviews, but they're sharing their stories, and their courage is showing the way for us to move forward and address these problems. The National Center on Sexual Exploitation is working with the Haba law firm out of Orlando, Florida, and representing 2 young men who were sexually exploited and then had child sex abuse material, images of them at the age of 13 mass distributed on Twitter. I'm going to play just a moment, about 3 minutes, of an interview with the mother of one of these courageous young men. And she's going to share just a little bit about what it was like for her son and what it was like for her as she found out about her son's child sex abuse material being placed out on Twitter.
So at that time, when I just honestly was seeking God, God, honestly, the Holy Spirit told me to reach out to a friend that I hadn't talked to in about a year. And that friend gave me Lisa Hava's name. And the contact with Lisa Hava was actually the first initial contact was just trying to get her to write a cease and desist letter for Twitter to try to get it offline because I couldn't figure out how to get it offline. Local law enforcement kept promising me they would get it down. Principal at the school promised me they would get it down, and day after day, no one was getting it down. I literally felt so helpless and had absolutely no idea where to turn. So we reached out to Lisa. She started checking on the cease and desist letter. At the same time, we were writing I put in the formal complaints to Twitter. We were asking them to please take it down, pleading and begging with them that he was a child. We would get automatic replies in the beginning, and then emails, that they were looking into it. Another email that they wanted to prove his age. At this time, during all this trying to get it down, honestly, I just felt so lost, and we continued to pray, and just honestly, God showed up, and my pastor called me and he said, meet at the church at 4 o'clock this afternoon. And he knew a federal agent. And up until then, every law enforcement officer that talked to my son made it like he was the one in the wrong. Everybody kept passing it off as just a sexting issue, and it was just boys being stupid. That's how it felt. Maybe that's not necessarily what they said, but that's how it felt. But nobody was pressing on. The federal agent looked at my son after he asked me to tell me the story. My son told him the story, and he right away said, "You have been a victim of a sex trafficking crime, and this is not your fault." It was the first moment that someone listened other than Lisa. And from that moment forward, the officer said, "I'm going to help you." Within hours of the federal agent started working on it. It was taken off of Twitter. In the meantime, just to back up a little bit, Twitter had asked for my son's so in the videos you could see my son's face. So there was no questioning with the ID that we sent in. We sent in a driver's license that proved his age, which at the time was 16, and a face to prove that. So after that, they sent an email back. Honestly, I can't even comprehend it. The email back, without reading it word for word, basically said that they had viewed the material or assessed the material and it did not break their policies. But I think what was more disturbing is instead of saying it doesn't break our policies, but we'll continue to investigate, or something to the fact of that, to at least be humanistic in this, they said it doesn't break our policies and basically no further action will be taken. That if we thought so, we could basically file another complaint if we wanted to try again, is how I interpreted it.
So just to recap what happened, this young man at the time of the exploitive images were created was 13 years old. And then when he was 16, they started being circulated on Twitter. This young man contacted Twitter and said, "I am a child. Here's my driver's license. Here is the video that is being circulated on your platform right now to hundreds of thousands of users." And Twitter responded in writing and said, "We have reviewed the material that you have shared with us. It does not violate our policies or procedures, and we are not taking it down." This was clear child sex abuse material. And because the young man had provided his driver's license, Twitter knew that he was a child. He was clearly depicted in the images. Twitter claims to have a zero tolerance policy for child sex abuse material. But clearly that policy is not worth the paper it's written on when this type of situation can happen. And as this John Doe and another John Doe are bringing their claims and have filed a federal lawsuit being represented by the National Center on Sexual Exploitation and the Haba law firm, Twitter is defending against that lawsuit and raising an absolute claim to immunity under Section 230. In December of last year, a very important article ran in the New York Times by the columnist Nicholas Kristof. It was called "The Children of Pornhub." And it had a significant impact. And what we're going to talk about now as we close our time out together is just what a powerful year it was and how much progress was made. And a lot of that progress really dates back to December when this article came out. Mr. Kristof wrote a very extensive piece. He clearly researched it very well. He spoke with scores of survivors of sexual exploitation and abuse, including this young lady. This is Serena. Her story is absolutely heartbreaking. As just a young teenager, she trusted someone with an intimate photo, and it was spread all over the world and turned into an abuse video on Pornhub. And then Pornhub refused to take it down. Serena's story and the story of many other survivors absolutely captivated the world, and especially Canada, where Pornhub maintains a corporate headquarters. Here's an overview of what the last year has been like. Nicholas Kristof filed his report with the New York Times, The Children of Pornhub, in December. 6 days later, the Canadian Parliament launched an official investigation into Pornhub with one of its committees. And it was a very extensive investigation. It included witnesses. It subpoenaed the executives of Pornhub who were there in Canada. They spoke to many survivors, and they spoke to even service organizations that were supporting survivors. The National Center on Sexual Exploitation, among many other organizations, provided evidence to the committee. And then the committee released a very searching report in June of this year. In January, the first class action lawsuit against Pornhub for representing survivors of abuse was filed in Canada. It's the first lawsuit in the world raising the issues, raising the rights of survivors against Pornhub. Also in January, the National Center, along with the Haba law firm, brought a federal lawsuit against Twitter. That was the lawsuit that we just spoke about and you heard the interview from. In February, the National Center was part of the first American class action filed against Pornhub. That was filed in the Northern District, federal court for the Northern District of Alabama. Also in February, the National Center filed, also in February, a second class action was filed by other law firms, this time in the Central District of California against Pornhub. So the count of American class action lawsuits against Pornhub currently stands at 2. In March, the National Center filed a similar class action as the one it filed against Pornhub against Xvideos. Xvideos is another company that has a tube-style platform where users can essentially upload any type of sexually explicit video they want, and often rape videos and child sex abuse material are on that platform. In April, Nicholas Kristof wrote a second story, which is well worth your attention. Why do we let corporations profit from rape videos? This time he turned his attention from Pornhub to Xvideos, which is located in Europe. And the article focuses on the challenge of European regimes, such as the Czech Republic, that do not hold corporations accountable for their behavior. In June, the Texas Supreme Court ruled that sex trafficking claims can move forward against Facebook and Instagram. This is a landmark decision, and it's something that Facebook has fought against adamantly. But it clears the way for essentially what Congress wanted to have happen when it excluded sex trafficking claims from Section 230. It's a very important case. And the National Center on Sexual Exploitation, among many other organizations, submitted an amicus brief in support of the survivors in that case. You can hear from the main attorney in that litigation, Annie McAdams, in the panel on Section 230 that's also part of this summit. And then finally, also in June, another very important lawsuit, federal lawsuit, was filed against Pornhub in the Central District Federal Court in California. It's filed on behalf of 34 different survivors, including Serena, who was the young lady featured in the original Children of Pornhub story back in December. So that's an overview of what the last year has been like. It's been an important, powerful time frame. So the question is, where are we now? And what are the key takeaways for us? Is it true that accountability is really rising when it comes to sexual exploitation online and on social media? The first thing is, it's important to recognize that we are at an inflection point. Things are happening at a very, very quick pace. It could always be said that the law sometimes lags behind technology, and that's probably part of the reason why Section 230 has had such a restrictive interpretation that's been so harmful to so many. But as the human trauma expands, as we have so many different stories of how people have been harmed, now is the time for lawmakers and judges to appreciate the significance. And now is the time for everyone to step forward and make a difference. And the voices of survivors and the voices of other advocates who are working on this issue are making a difference. Now is the time. Parents, it's so important to continue to talk with our children. This is not the type of situation where one conversation will suffice. The peril, the danger is daily. It is minute by minute. Most children, most teenagers have a device in their pocket or in their hand that can bring extreme harm to them, and traffickers are targeting them. They need to hear from us on a regular basis. I'm a parent and I appreciate the challenge. And I wanted to share with you in this presentation just the voice of other parents who have seen their children harmed. It's one of those things where we have to step up. It's one of the great challenges for parents right now at this point in time. And I encourage you to continue speaking with your children. Don't just make it one conversation, make it multiple conversations. Make it a regular practice to check in with them and ask them how things are going on their social media. Survivors, your voice is so powerful. It is making a difference. Voices of courageous young women like Serena are making sure that young people like Daniel, who lost their lives in dangerous situations, they're making sure that more young people are kept safe. We owe you a debt of gratitude. Thank you for being brave. Thank you for sharing the intimate details of what has happened to you with the world, and your story is turning the tide. And then for all of us, this challenge is a significant one, but it's a collective challenge, and we are making a difference. The last year has brought about unprecedented change. I'm encouraged by that. I hope you are. At this pace, we're going to see lasting change come and come soon, but it will only happen if we work together, if we support survivors, and particularly lawyers. I just want to speak to you as advocates. This is a place where the rule of law has fallen down. And this is your opportunity as a lawyer, as an advocate, as an officer of the court, to bring the rule of law back, to open the courthouse gates for an important category of vulnerable people who are being exploited. I encourage you to find ways that you can support this work. At the National Center on Sexual Exploitation Law Center, we have a team, and we appreciate every law firm that has stepped forward to help us, whether it's directly supporting litigation or appearing with us in pleadings in federal and state court, working with us on amicus briefs, working with us to provide research support, or perhaps to prepare for oral argument. I just want to thank you as an attorney. Thank you for what you're doing. Thank you for your commitment. Together we will make a difference. The Law Center exists to use the legal system to end sexual exploitation and abuse. And the last 12 months have shown that it is possible to make lasting change. Together, as we team together, we're going to see powerful and lasting change. And I just want to encourage you, whether you're a survivor, whether you're an advocate, whether you're a parent, whatever your role is, you can make a difference. Thank you very much for taking your time and being with me for this. I look forward to meeting you during the course of the summit. The Law Center is going to host a few meetups. So if you would like to meet with myself and the other attorneys who are on our team, I'm very much looking forward to that. And I hope you have the time and the ability to participate in one of those meetups. Thank you very much for your time and for listening to this presentation.